We're all here. Good morning. Recollections may vary. The Queen knows it, the judge knows it, and now, quite simply, we have to know it. We're 2 years into a new practice direction. We've had a raft of cases with no sign of that flood slowing. So we thought this time to reflect, time to consider. When I took Silk, I was given one piece of advice, which I keep repeating: surround yourself with good juniors. As my close friend said, you'll need it. And I have that on this call. In the order in which they told me they wanted to be introduced: James Bradford, specialising in commercial and chancery litigation, special interest in cross-border and offshore litigation. He's fluent in Italian and English. That's going to become important later on. Johan Ho, who I always say crossed from the dark side. He was a solicitor in a city firm. I'm sorry, Johan. Specialises in commercial and construction disputes. He transferred to the bar in 2016. Now he's fluent in English and Mandarin, and we'll return to that as well. Ruth Keating, dual qualified barrister. She's qualified both in England and Wales and Ireland, and she specialises in construction, energy and climate change. She's got a very interesting podcast series running about that. Gethin Thomas, who's a barrister with a very broad practice spanning both the public all the way through environmental to the commercial. He's on both the AG's panel in England and Wales and on the government of Wales, the Welsh government's panel. And last but far from least, Philippe Kuhn, who specialises in cross-border commercial and construction disputes, and he's called to the bar in England and Wales, the BVI, and I think ad hoc also in Gibraltar. So there's a range of experience there, which I think is going to become important. Two quick things: questions, please. Yes, we want them. Now have a look now and locate where they are. There's a Q&A. Please, if you want to just put them to us. I think we've also got the chat function. If we have put that in there, any comments in there, we're going to monitor both. We are also going to poll, and here it pops up. We thought we'd set the tone. I'll give you 30 seconds. Please, would you now indicate your views? Do factual witness statements now perform their core function, achieving best evidence at proportionate cost? Yes or no? I know you're lawyers, you hate the binary choice, but that's what you've got. We're not going to publish particulars of the results. We may use the general trend, but that's all. Go on, put your answer in now. And I'm going to see, actually, I should vote, shouldn't I? Let me submit mine. Okay, Philippe, would you like to share with us? Do we have the answers there? Well, that's pretty clear, isn't it? Let's see if we can flush out why and what we can do about it. We have left 10 minutes at the end for questions, but I know from experience we've got an awful lot to cover. So put your questions into the chat or into the Q&A box now, so we can start to think about how we build them in. Now, let's have a quick look at the structure. Can we put the slide up? Interestingly, I think the eagle-eyed among you, and also perhaps those with an elephantine memory, will see how that has changed. That's not exactly what was on the flyer. It's been supplemented. Those are, we think now, having gone through a vast number of recent cases and reflected and discussed. What's the problem? Do I have to worry about this? What can I do about it? And there we're going to narrow in on what's acceptable in witness statements and their accompanying documents. What do I have to do about it? Or what will my opponent do? That's pretty much what was there. These are the questions that have come out, though, reflecting recent cases and also what's becoming to us one of the key questions. Is my witness lost in translation? And does my witness's demeanour now matter? And then we're going to try and wrap it all up and give you some crisp, clear takeaways. There will be a handout. So we will send everyone who signed up for this a list of the cases that we are referring to. So don't worry about capturing that. You can also, of course, email us at any stage and we will give you the link to what we're saying. There is, although we talk quite fluently and easily about this, there is an awful lot of research behind it, which we're willing and able to share with you. So that's enough from me. What's the problem? let's go to that. Gethin, does memory matter? What is the likely approach of a judge to human memory? What do judges expect?
Thanks, Marion. Well, the key case on what judges expect in England and Wales is the decision of Mr. Justice Leggett, as he then was in Gethin, case from 2013. Now, the headline point from the case law generally, Gethin in particular, which is also reflected in psychological research, are that 1, human memory is unreliable. 2, memory is not a mental record fixed at the time of the experience of an event. It then fades more or less slowly over time. And then thirdly, memories are fluid and malleable, and they're constantly rewritten whenever they're retrieved. And the courts have been alive to recent developments in the scientific understanding of memories, recognize that memories are fluid and malleable, being constantly rewritten whenever they're retrieved. And that's a quote from Gethin. And it's notable that the phrase fluid and malleable is itself also used in the practice direction at paragraph 1.3 of the appendix. And Mr. Justice Leggett also observed in Gethin that considerable interference with memory is also introduced in civil litigation by the procedure of preparing for trial. And the statement of best practice also reflects those principles of Gethin.
And I wanted to pick up on that because the statement of best practice says those who assist witnesses in giving witness statements need to be aware of what you've just said. Why is that?
In short, because the process of civil litigation itself subjects the memories of witnesses to powerful biases. And it was summarised by Mr. Justice Nugi in a case called Walsh and Greystone Financial Services Limited, that the best chance of a person giving an accurate account of a memory is if they're asked to state what they recall without having previously asked to do so or having gone over it. 2, they haven't been exposed to any other information about the event or had any suggestions made to them by anyone else. And then 3, that they have no personal interest in giving a particular account or particular understanding. But problematically, the processes of civil litigation usually mean that oral evidence given at trial is under the very antithesis of those conditions.
Yeah, I know, James, you wanted to come in on this as well.
Thank you. Yeah, absolutely. I think, as Gethin said, the sort of scientific consensus now is that witness statements and memory in particular is particularly vulnerable to interference. I think in the context of civil litigation, we can see that in a number of different ways. And I think everyone on this call, in this seminar who's been involved in preparing a witness statement will see this. In particular, there are the dangers which come from the fact that the statement is done many years after the event by its very nature. The fact that the lawyer involved just in the process of even asking open questions is in a proofing session with a witness is at risk of moulding that evidence and that shaping that memory. And you also have the idea that a witness is going to, by reading the documents maybe 5 years after the event or 3 years after the event, is going to be refreshing their own memory and perhaps alighting on different things and putting different nuances to even emotional reactions. So yeah, there's a lot of dangers which are particularly acute in the civil litigation context.
I mean, scenes you don't want to see are the witness statement which starts with "once upon a time."
Right, quite.
And you don't have to actually say that. That can be the conclusion the judge draws. Is that the only driver behind this reform? Is there anything else that you think is pushing the reform? I think, Johan, this is one for you.
Yeah, so when you look at the genesis of this practice direction and you look at how it came about, the working groups that looked into this, it really came about from a concern that users, all court users and judges had, and that is that witness statements were becoming too long and over-lawyered. By the time they got to trial, they were often very much the work product of the legal team, having had many iterations with the witness. And that is why there's such an emphasis in this practice direction for witness statements to set out the evidence in chief that a fact witness would be giving orally if there were no written witness statement. So in many ways, we're going back to the classical period where you get the best evidence of someone talking and being walked through what had happened. So that is very much the golden thread that guides what witness statements should be nowadays. And the working group also looked at some of the worst accesses of how witness statements had become inappropriate recitation of documents, commentary, argument, and all of that meant that the court was not being given the best evidence, by which I mean true, untainted recollection of factual matters that that witness experienced.
Yeah, I think those words, the words that resonate for me, the best evidence. That's what we're pushing for. Let's move on to our second question. Do I have to worry about this? Can we share? We've got a poll question to share at this point. This webinar is only of interest and use to those who practice in the business and property courts. It's still binary. I agree. I disagree. Give you 30 seconds. One of the things you'll discover on this webinar is I cannot estimate time. Let's have a look and see what the results are. Good, good. Let's dive into that. Philippe, let's start by just reminding us, where does practice direction 57AC actually apply?
So the starting point generally to the business and property court. So that was the premise of the poll question. So if you're a repeat player in the commercial court, most proceedings in the Chancery Division, but there are some exceptions, and the TCC amongst others, the Admiralty Court as well, you should be now, 2 years in, very familiar with this practice direction. However, it's for trial witness statements. So the practice direction makes very clear that it doesn't affect affidavit evidence, which you still find in freezing and search order and certain other applications. It doesn't affect other witness statements, maybe for a disclosure application or something anodyne like that. And it also doesn't affect the general powers of the court under CPR 32(1 to control, exclude, or limit factual witness evidence.
Yeah, and I wanted to pick up on that because you really cannot salami slice the CPR. You've got to look at it holistically. And James, to what extent do we see the principles of 57 reflected in 32?
Well, I think they go hand in hand, and there is a natural overlap. That one of the cases that I believe is on the handout, it's a recent decision from last year, Correa and Williams, sets out the framework and the overlap to some extent between CPR 32 and the 57 practice direction. And of course, the certification is not only of that one has to do is not only of compliance with the practice direction 57, but also with the other practice directions and elements of the CPR, including 32. So, and just to remind people of, for instance, what 32 covers, which was the starting point before this practice direction, it's in this essence, the key parts are found in paragraph 18, the idea that the witness statement must be in the witness's own words, for instance, and that the requirement to set out how the witness statement's been prepared. And of course, as everyone here knows, practitioners need to also be mindful of the various court guides. So the commercial court guide, the Chancery Division guide, King's Bench guide, which have their own sort of supplementary guidance that one needs to follow.
I think we see in that, don't we, this Johann's message, which is you can't use the witness statement as a vehicle for advocacy. That's been a constant theme across the courts. So what I'm getting from you is that you've got to, don't regard this as being in a box, as our audience already doesn't. This is best practice, and this is already in the rules applying across the section. Gethin, you talk to us about Guestmin and this concern about the malleability of memory. Are we seeing that reflected across the spectrum in the case law?
Yes, it is having a very wide impact. You see Guestmin being cited frequently and extensively. You have to sort of go on the Westlaw page and see the flood of cases that refer to Guestmin, and across quite a broad range of areas. So just briefly to take 3 examples of where it frequently crops up. First, professional discipline cases, in particular in the context of challenges to professional discipline outcome decisions. Obviously, in those decisions, witness evidence is usually critical to the determination of misconduct allegations. And you see in cases, for example, Dutta in the General Medical Council or Solicitors Regulation Authority in Day, the principles of Guestman being cited. The second area where you see Guestman principles frequently referred, cases concerning the application of Section 33 of the Limitation Act 1980, where the court's exercising a discretion or not to allow claims for personal injuries or death after the expiry of primary limitation period. A notable case in particular is Carmarthen and the Foreign and Commonwealth Office from 2018. In that case, Mr. Justice Stewart expressly decided to use a bit of caution in applying to the disadvantage of the claimants what he referred to as the full rigour of Guestman, but he recognised the problems of relying on largely uncorroborated evidence so long after primary events, and this malleability of memory issue was something that ultimately was a hurdle couldn't be got around. And then thirdly, we're also starting to see Guestman cropping up in judicial review of general public law decisions. Although witness evidence is not usually front and centre of judicial reviews, Guestman's reach is having an impact. And there's a recent case, British Gas and Bays from this year, judicial review challenge to energy decision in the divisional court. It involved a very substantial degree of disclosure, and there were a lot of extensive written and oral submissions about what conclusions should be drawn from that material, and the court expressly reminded itself of Guestman and the greater reliability of contemporaneous documents over the recollection of witnesses.
Yeah, that is an interesting question. I'll just take the last one in the questions that are coming in. Do keep them rolling in. There's one, does it apply to mediation statements used in mediation in a case which is in the business and property courts? My take on that would be, and anyone can chip in on that, is that, as Philippe was stressing, it's trial witness statements, not mediation statements. But you've got this general principle that's emerging, that everyone who reads a statement now has got these principles at the back of their mind. So if you want to produce something that is going to have the greatest weight, which is what this is all about, you need to be aware of them. That would be my take on it. Anyone want to chip in before we move over to the third question? No, let's go on over to what can I do about it? Topic number 3. What can I do about it? What is now acceptable in witness statements? Ruth, I want to bring you in here. Let's get the poll question up, and I'd like you to sort of take us through. That's the question. I need to know the letter and not the spirit of PD57AC. Okay, this is very much Ruth's topic. Everyone vote. We should have made that one agree or disagree, but there we go. I think with a clever audience like this, that's not going to trouble anybody. Would you like to share the answer? What's the poll answer? Interesting. 20, roughly 3/4 saying, no, I need to know the spirit, but 25% saying it's a checklist, just follow the letter. Interesting. Ruth, over to you. What are your thoughts?
Well, thanks, Marion. I think that was phrased somewhat of a trick question in a way by us, but I think it's a really interesting discussion. It's one that James is going to bring up later when he's talking about translations, and it's very much front and center in terms of practice direction 57AC, that ethical interface between these rules and the issues that arise in practice. So there are clear purposes behind these rules. The other panelists have made that really clear, but we can also see the theme of some of the questions in the Q&A already. And a lot of these questions are, well, what am I to do about it? How do I resolve the individual issues that arise in my case? Now, of course, the practice direction, it's very much focused at achieving best evidence. It's focused at achieving overly lawyered statements, and it wants to avoid comment. But I think when the practical issues arise on the practice direction, the questions I always think people need to keep in mind when they're advising on it or they're considering these issues is, what is the rule trying to achieve, and what purpose will be undermined by the course of action that I'm proposing to take? So from my perspective, certainly, if you approach it from a purposive approach, sometimes the answers are clearer, but it's certainly not a practice direction that's about technicalities. It's very much about the spirit of the practice direction and what those rules are trying to achieve.
And it's the two themes, isn't it? It's protecting the integrity of the memory and avoiding the over-lawyered statement.
Absolutely, Marion.
So how do you get the course between? Can I just clear, all right, 3 general points. First of all, has the practice direction changed the law of admissibility of evidence? Philippe.
The short answer is no, and that was confirmed in a commercial court case called Mad Atelier and in a TCC case called Mansion Place. And we've got more recent statements to that effect from Mr. Justice Meller in the Chancery Division in Lifestyle Equities last year, where he said doesn't change the law as to admissibility of evidence or overrule any previous authority on how evidence may be given. And then also in the Chancery Division, we have another judgment, Primavera Associates, saying this in terms as well. So the driving force is it's about eradicating improper use of witness statements. It doesn't change the old rules on admissibility.
Yeah, that's the clear first instance message. And insofar as I'm ever prepared to predict anything, I can't see the Court of Appeal changing that. Now, let's second basic question. We know there's the statement of best practice attached to 57AC. Now, what have the courts said about the use of this statement of best practice? Johan.
In one line, use it as a checklist. It is there not as a nice to have, it is there to make sure you comply, so you have to use it. And this was emphasized in Mansion Place, where the judge stressed the importance of that. And again, using that golden line, you have to put forward the evidence that the witness would give as oral evidence in chief in written form.
And Ruth, if you had to identify one or two cases as providing the best route into the case law, what would you say?
Thanks, Marion. So there are lots of judgments now. I still think two of the best judgments are either, as Johan said there, Mrs. Justice O'Farrell judgment in Mansion Place. And also the second judgment I would say is His Honour Judge Stephen Davies in Blue Manchester. Now, in terms of both of those judgments, Blue Manchester in particular has these examples at the back. I would say use them with a degree of caution given the length of time we've now had the practice direction. I think they're a good indication of what not to do, maybe not the best indication of what to do, but two really good examples of judgments for people to read.
And let's now turn to look at things that might be happening. Let's start with block copying. Is it still happening? Should it still be happening? I know a number of you have got views on that. Let me start with Johan.
Yes, it's still happening, and no, it shouldn't happen. Blue Manchester addressed this squarely, and the judge there said it was difficult for him to see how this could ever occur if the requirements of the practice direction were conscientiously complied with. And he emphasized that a lawyer can take primary responsibility for drafting a witness statement, but that does not justify departing from the requirement that a witness statement should be in a witness's own words. Can I just add one more thing, which is to note that Blue Manchester was a fairly early case when the practice direction was set out. And over time, I think we've seen that judges are getting a little bit more strict, as you would expect. So I really cannot stress enough the importance of using the statement of best practice and complying with it.
Yeah. And Philippe, I know you wanted to say something about this as well.
Yes, I mean, I think sort of prime example of Johan's point about judicial tolerance waning is quite a cutting passage from a judgment given recently by Mr. Justice Fancourt in Mackenzie and Rosenblatt. And just to summarize it briefly, it's at 145 and 146, if you want to read it. There were 4 witness statements. The judge says, the 4 witnesses, having heard them, were different personalities and had very different levels of recall of events. However, the witness statements were given in a uniform style and tone. And then he goes on. And then this is quite, blunt. He says in the next paragraph, these witness statements are the careful work of a legal team, contrary to the requirements of PD57, that a statement should be as far as possible in the witness's own words. And then he says they resemble a position statement seeking to advance a case more than a witness statement, and that it had left him, or each of these statements had left him with real doubt about the reliability of their content. And now, that's a really damning assessment. And we discussed this internally. And so my own very personal take on this is, I've got a lot of sympathy actually for what's happened here, because in a practical sense, to avoid some level of style or tone, Either you need to have different solicitors drafting each statement if you want a slight sort of mix-up, or the more sort of probably judicially approved or endorsable approach would be to not deviate too much from your original proof of evidence, as much as that may look quite unedifying as a sort of piece of text. So the sort of editors in you have to resist that urge to over-edit.
It's really difficult for the advocate, but the comfort blanket has been taken away. It's the witness's own words. And if you do that, it should not have the same tone. Ruth, can I bring you in here? Have we got any more judgments on it?
Yes, Marion. So I think when you asked Johan at the beginning, is it happening and is it still happening? It's yes and yes again for the case of Kieran Corrigan. So that's a decision of this year. And what's interesting is we see specifically in that judgment, the judge saying, I was concerned, particularly in light of the breaches of Practice Direction 57AC, that there was a number of statements containing identical or similar passages at important junctures. So I think that's another thing to do, is it's very difficult sometimes to eradicate that language, but do think about the important junctures of the case and pay particular attention to avoid it in those parts of the statements.
Let's move on now to have a look at the source of the information. My impression is that in the early days, they were stressing that you need to identify the source of information on which a witness is relying. Is that still the case, Johan? How strict is it?
That is still the case. I think you have to approach it with some pragmatism. The general principle has been repeatedly stressed in a number of cases, and in Blue Manchester, it was stressed by the judge there that it should be clear where evidence comes from, whether it's from the witness's own unaided recollection or whether the witness has been referred to documents and so on. The judge was very clear he should not have to engage with guesswork. So how one complies with that, every case, you have to approach it with a degree of pragmatism, especially if you have a very long witness statement. But I think that is the golden thread. A judge looking at it shouldn't have to guess what the source of the information is.
Let's. I can see from the questions that are coming in that it's the use of documents and how you marry the witness's recollection with the documents that appears to be causing the most concern. Let's start with, what about setting out the terms of the contemporary correspondence in the statement? Is that acceptable?
So, Marion, we do have in the practice direction, it says explicitly that a trial witness statement should refer to documents, if at all, only where necessary. So that's the standard that you're having to meet. In terms of what judges have said about this, Marion, you've already used the term comfort blanket. It's one that's probably borrowed from Stephen Davies in Blue Manchester, where he said that lawyers need to be prized away from that comfort blanket of feeling the need to confirm a thread of correspondence. And certainly that's something we would have seen in statements before the practice direction. You can still use documents to good effect. So if you think about it this way, if a witness is talking about a conversation they had or an email, it can be sufficient to convince a judge of the truth of a party's recollection by perhaps referring to that conversation or a contemporaneous note of it. But there are other examples where we see that you have to achieve that balance. So lifestyle equities, again, is a decision of this year. If we take an example from one of those statements, so it's Mr. Haddad, paragraph 21 of his statement, which is cited in that judgment. And at the end of that paragraph, it says, the brand had also enjoyed substantial media coverage and won industry awards. And then the witness statement says the claimant's disclosure contains documents that show that those activities, and I do not need to duplicate those documents in this witness statement. Now, Mr. Justice Meller didn't take a generous approach to that. What he said was, and this is a quote from it, that sentence displays a deep misunderstanding of Practice Direction 57AC. So a fairly brutal description there. And it says, I assume on the part of the claimant solicitors. And then he continued in terms of that aspect of the statement to remind us again of that purpose. So again, bring yourself back to the purpose. It says, the purpose of a trial witness statement is to set out in writing the evidence in chief that a witness would give if they were allowed to give oral evidence. And the judge said, Mr. Haddad would have been entitled in oral evidence to refer to those awards. And indeed, counsel would have been entitled to cross-examine him. So it's something that should have been identified in the documents. And then finally, it says it's completely inadequate simply to insert the sentence that they did saying the disclosure contains the documents, because as Johan says, then the judge is left guessing. And it says, without the lack of an explanation, I'm left in a position of having to guess effectively what each document says. and the purpose of those documents. So you don't want to be on the receiving end of that judgment, it's fair to say.
And he was also heavily critical of the fact that the first time he's told what the documents might be is the annotation in the witness statement in the trial bundle. So we can see, I think, in the cases, the grappling with the problems as we've had this practice in place, and the cases are now coming through to trial. So it's a very interesting period, I think, in the next 12 months, when we should see a flood of cases grappling with the witness statement, new rules, the recodification or the restatement of the rules. I think it's wrong to say they're new rules. One of the things that was concerning people was, what do you do if a witness wants to add thoughts or comments about an event when there are documents in existence about it, say the minutes of a meeting? Philippe, I think you're going to address this one.
So in principle, that's perfectly permissible, and in many cases it can be helpful. So the sort of unhelpful caveat in the case law is where relevant, which is we get that from Blue Manchester again. And what you might have is a situation where there's meetings, emails, and so on, but the witness might still be able to plug in certain gaps, and that's where I think Stephen Davies and other judges see the witness adding value. But if they can't really add anything, then don't do it, because then you invite the error of those same judges. An example where that legitimate remit was overstepped was in Primavera, and the criticism there, and this is sort of one to look out for, a witness had started commenting in his statement on a meeting that he didn't attend. So it was quite difficult for the judge to see how he could have had any thoughts of something he was unaware of at the time.
Yeah. Let's move now to have a look at the list of documents where you have to attach to the witness statement, the list of documents that the witness has looked at. Gethin, do all of the documents that the witness looked at have to be listed? Have you got any guidance from the courts on that?
Yes, there is some guidance. So what Mrs. Justice O'Farrell said in Mansion Place was that the purpose of that rule is to provide transparency in respect of the documents used to refresh the memory of the witness, so that the court and the other side can understand the extent to which, if at all, the witness might have been influenced by the contemporaneous documents, including those not seen at the time. On the particular facts of Mansion Place, Mr. Justice O'Farrell concluded that there was no indication that the documents that hadn't been referred to had been used to refresh the witness's memories. And in that case, it wasn't unsurprising, because the key exchange in question was a telephone conversation. So the lesson is clear. If you're using the documents to refresh a witness's memory, which is perfectly permissible, then the court has to have the benefit of the evidence which has been used for that purpose. It needs to be clear what the witnesses looked at when they were preparing their statement.
Yeah. And just before we go to Ruth and look at the process, I think I know the answer to this, but I ought to ask you, James, what if a witness doesn't know something but wants to include a guess in the witness statement?
Generally not a good idea. There's a recent decision which will be in the handout. Let me just get the pronunciation correct. Litcraft Limited and Cottrell, where the judge commented exactly on that and rebuked one of the witnesses for guessing. For everyone's reference, it's paragraph 124, and the judge made the comment that at 4 times the witness made reference to guessing about factual matters. A witness's guess does not fall within the proper ambit of the contents of a witness statement that complies with paragraph 3.1 of Practice Direction 57AC. So I think that's a very recent, very clear rebuke of any suggestion that guessing would be appropriate within the rules.
And Ruth, over to you. The process, and that's what a large number of the questions are also reflecting. What guidance are we getting now from the courts about the process of taking witness statements? There have been some interesting practices, haven't there?
There have been some interesting practices, Marion. It's a generous adjective, but I think our listeners will understand why. So one case is Bastome and Peveril Securities. That's, again, a decision of this year. I think, again, that's a helpful example of what not to do in terms of drafting statements and how the process should be conducted. So in terms of that, at the PTR, the court struck out the claimant's witness statements for non-compliance, but they did say you can have replacement witness statements and they need to be served at the start of trial effectively. But it then became apparent at the trial stage that those statements also weren't compliant, and there were a number of reasons why. So witnesses hadn't been interviewed separately. That's a pretty fundamental requirement. And what had essentially happened was those witnesses had signed mass-produced statements which were drafted by the solicitor from generic documents and then unidentified instructions. So going through those, there was a final blow, which was also that it contained inadmissible evidence, so without prejudice negotiations. We have a couple of examples from another case, so lifestyle equities, one which we've discussed already. And I think it's helpful to look at specifically what happened in that case. So the judge said that a cause for concern in relation to two witnesses, so Mr. Emblin and Mr. Reid, was that parts of their witness statements contained identical language. So that's something we've seen in other examples of cases. We have a better understanding in lifestyle equities as to why that might have happened. So in cross-examination, Mr. Reid explained that he had read Mr. Emblin's first witness statement when writing his own witness statement, and that parts of it had been copied from that statement, because the way he put it in cross-examination was because what he said chimed with my own recollection of what occurred. And I think we can all understand why that's a problem and why your heart might sink if you heard that from one of your own witnesses. What also came out was that Mr. Emblin was present in the video and telephone calls with the solicitors where Mr. Reid's witness evidence was being prepared. So that was another problem. And I think what the judge made really clear was it said one witness should not copy the evidence of another witness. That's fundamental. They need to give their own account, and that's regardless of whether their recollection is the same. And without good reason, the judge couldn't see why a process such as this was followed in this case. So I think that's really the key, is to avoid any cross-contamination. That's through documents, but it's also through the process itself.
Let's move on now to our fourth topic. We'll have to take this one quite quickly. What do I have to do about it, or what will my opponent do about it? I'm going to take this section really quickly, but I will give you a little time to answer that question. My failure to follow PD57AC will have no effect on the judge's assessment of the credibility of the witness. Do you agree or disagree? Shall we see? What's the answer? That was almost 100%. Interesting. Very interesting. So Ruth, is it Ruth? No, I think in fact it's going to be James on this one. Over to you.
Yeah, I think just to kick this topic off, I think there's a couple of recent cases which set out the powers, or the sort of range of powers that the court has in relation to non-compliant witness statements, and indeed the sort of at times pragmatic approach that the court will have. So returning to that decision in Litcraft, paragraph 126, the court set out essentially three different options that they considered. So they could either disregard the witness evidence altogether, they could reflect that in non-compliance orders, or most simply, they could just, it would affect the weight which would be attached to that witness statement. And again, we see that quite pragmatic approach in another decision, which will be on the handout, in Brendan International Limited and Water Plus Limited decision of last year, where again, the court said effectively with regards to a non-compliant witness statement that they just wouldn't have regard to it when forming their conclusions. So again, a question of weight or disregarding it altogether.
Yeah, and I think Johan's got is going to talk to us about Brendan International. Is that right? Because my impression is, looking at them, is that the judges, if it gets through to trial, a judge is going to have a good long think about the weight to attach to a statement which doesn't comply with the best practice. If anyone disagrees with that, shout. But I think what I'd like to do is to move on to the striking out, because we were talking about the possibility of striking out parts of the witness statement. Does anyone want to chime in on that? Any guidance about when and where and in what circumstances to apply, or will the order be made to strike out?
I can jump in there, Marion. So there's a quick cautionary point on being too trigger happy with a strikeout application. Primavera Associates Limited and Hertsmere Borough Council, which is a case from last year on the handout. And in that case, the defendant made an application at the PTR to strike out one of the claimant's witness statements. And His Honour Judge Paul Matthews emphasised in his judgment that it is for the party applying for the strikeout of the witness statement or paragraphs within it to prove their case. It's not enough to point to examples, even egregious examples, which perhaps show in a statement you've got argument rather than factual evidence. And that doesn't reverse the burden of proof. And the lesson, key takeaway, is be precise in your criticisms and be reasonable. General assertions won't cut it.
Costs, dreadful word. Anyone got anything that they would wish to say about the costs, either of the application to strike out or cost orders that are being made at trial? I think, Philippe,
Yes. So this is probably my favorite case of all the cases on witness statements. And it's a decision in Curtis and Zurich Insurance last year. And this was, heavy group litigation. Zurich applied for strikeout of all of 4 statements and parts of another 29 witness statements for breach of the practice direction and statement of best practice. Enormously expensive application. The judge remarked that the total costs incurred by both sides on this application, excluding VAT, exceed £275,000. I regard that with dismay. In my view, there is no rational world in which this sort of expenditure can have been justified on an application such as this. He then said the application was largely abandoned because it had been presented on a scale that was disproportionate and unmanageable. He described it as a major distraction and said it ought not to have been made. And then there was a sort of characteristic sting in the tail. Zurich was ordered to pay 75% of the claimant's cost, even though notionally Zurich had won the application, or at least parts of the relief that it had sought. And the point he made is, if one makes hundreds of points, there are almost bound to be some good ones. That does not show that the application was justified. And he said the application was not worth the candle. So if you're ever on the receiving end of a really rubbish, in your view, PD57AC application, I would trot out Curtis and Zurich.
and I think, Johan, are you going to talk to us about Kieran Corrigan?
Well, I was going to talk about Cumbria Zoo. I wonder that might be.
Talk about, I'm all for bringing the animals in.
Well, on the topic of favourite cases, I thought Cumbria Zoo was an important one to state on this webinar, because before I go on to proportionality, it was the first case, I think, where the courts made good their threat in naming and shaming, and the judge expressly identified the lawyer who signed the certificate of compliance by name and stated that, just reading from the text, that lawyer had either not read Practice Direction 57AC or has not understood it or is deliberately ignoring it, end quote. And if that sends a shiver down your spine, certainly did to mine, I think it's for good reason, where that's how far they've gone in critiquing and naming and shaming people who do not comply, the legal advisors. And on the point of proportionality and bringing applications, that in that case, what the judge did was he observed in his experience, most cases of non-compliance were minor. So you may have some non-compliance, but if it was minor, then that does not justify bringing an application. But of course, and I've given you the punchline by the naming and shaming point, this was a very egregious case. And the judge made clear that non-compliance in this case was substantial and flagrant. So I think if you apply that as a litmus test, if it's substantial and flagrant, you're not trigger happy in making the application. You probably should make the application. And the judge made clear that there was little prospect of the court allowing a party, because otherwise the beneficiary of an order of costs to recover the costs of a preparation of witness statement that's so grossly non-compliant. So there are, I think, many bad consequences that apply if one does not comply. And this goes back to one of the points that we've been making in this webinar, that compliance is really not difficult. And the courts have gone so far, or the judiciary has gone so far, as to give you a statement of best practice you can use as a checklist to ensure that you do comply.
Yeah, and in fact, I thought I saw something in the chat flit up, but I may have been mistaken, but I think it was to the effect that the experience in the courts are that witness statements are still not complying with PD57AC in the business and property courts, but I can't find that now. So just hold that thought there. Let's move on now to, is my witness lost in translation? Because we've been talking, everything we've been talking about is the first level of chess. It's the witness statement from the witness, fluent in English, mother tongue English. No one would even consider the possibility of that witness giving evidence in any other language. Let's talk about the cases which many of us on this call will have to deal with, where that is simply not the case. James, over to you.
Yeah, I'll try and not make this a shameless plug for instructions for those who can speak multiple languages on the call, although we will get to that for sure. I think it's worth just setting out a little bit of context on this in terms of how the rules have changed or evolved. And obviously it is a key factor to bear in mind when coming to proof a witness, and obviously then going to trial, what their language is and what they're familiar with. So obviously the original position was reflected in the practice direction of CPR 32, that paragraph 18, that a witness statement must, if practicable, be in the intended witness's own words and must in any event be drafted in their own language. Now, I'm sure lots of people on this call found some, and certainly I did, found some difficulty in practice with that, particularly where a witness spoke more than one language, and there was a query as to what that really meant in practice, in terms of which language the statement would be produced in. That's evolved in the practice direction 57AC, and the relevant paragraph is 3.3, where it says, for that purpose, a witness's own language, to quote, includes any language in which the witness state is sufficiently fluent to give oral evidence, including under cross-examination, if required, and is not limited to a witness's first or native language. So that's really the key criterion and the key test when we're talking about bilingual witnesses. And we've seen a pragmatic approach taken in the case law on this, and there are a couple of cases on your handout about this, but in particular, there's the decision from last year, Bahia and Sidhu, where essentially the witness could speak both English and Punjabi, had some hesitancy in English when he was under cross-examination, and obviously that's somewhat to be expected given the stress and pressure of cross-examination. But the court effectively found that there was no real issue here, because they didn't find that there was any evidence of pressure being put on the witness, and effectively the lawyers writing it without the witness just signing it off, which is again the nightmare scenario that I'm sure people have seen other parties do in court. Just a key takeaway from these cases, and then I'll just pause here, but a key takeaway from these cases is that I think the court takes a somewhat pragmatic attitude where the witness can speak English, but that might not be their native tongue. But one lesson that I think we would take from this, and certainly in our experience, is that if you can proof the witness and engage with the witness in their own their native language, so to speak, that's a real plus, because we've certainly found anecdotally that when you're proofing the witness and getting them ready for trial, if they're doing it in the language that they're most comfortable in, suddenly various nuances and expressions and emotional memory, let's say, will come out that perhaps they won't have or deliver if there's the barrier of speaking it in a different language. So I think that is a real, again, that's the shameless plug, but I think that is a real positive if that can be done.
Yeah, words matter.
Yeah,
I said
absolutely.
memory matters, but words matter. Witness demeanour. Let's move into the next one, because I think we're moving into this wider discussion about how will a judge or an arbitrator or an adjudicator, how will anyone decide what is or is not the truth? Because ultimately, it's a simple question. We're not in a post-truth world in the courts. Ruth, does it matter?
So Marion, I think you asked, do words matter? Words matter. Does demeanour matter? We've had some recent consideration of this, so connoisseur developments and Kuhn, and in that judgment, His Honour Judge Davis White, King's Counsel, gives a real description of the raft of authorities we have on this, and he summarises them in a really neat way. One judgment is by Mr. Justice McKenna, and I like it because it goes through some of the examples that we often consider to be demeanour, which indicates that a witness isn't to be considered reliable. So one of them is, he speaks hesitantly. Is that the mark of a cautious man whose statements are for that reason to be respected, or is he taking time to fabricate? Now, you'll notice, Marion, there's a slight Shakespearean style to this I enjoy. Is the emphatic witness putting on an act to deceive me, or is he speaking from the fullness of his heart, knowing that he is right? Is he likely to be more truthful if he looks me straight in the eye than if he casts his eyes on the ground, perhaps from shyness or national timidity? And the final bit I really like from this judgment is he goes through a number of studies that say that demeanour really isn't that reliable, and says while the studies mentioned involve ordinary people, there is no reason to suppose that judges have any extraordinary power of perception. So making an effort there not to offend any of his colleagues. But I think nonetheless, the point is clear that we might sometimes take certain hallmarks of human behaviour to mean a witness is unreliable, but ultimately we're not very good at assessing demeanour, and the documents and the words are probably going to be more reliable than those indicators.
And Philippe, questions in the box. The importance of the contemporaneous documents, how important are they?
Crucial, and there's a raft of authorities. Just sticking with the connoisseur case, the point is made again, and the judge there said, I treat all the oral evidence, so not just the witness statements, but even what the judge had heard at trial, with care, and primarily tested against the contemporaneous documents where available, as well as the inherent probabilities. So it's all going in the round, but if something is backed up by a document, you're more likely to make good the point.
Yeah, and I thought, Ruth, you and I discussed this and got lost, of course, down the rabbit hole of the web. I think you've got a great example to share with us and about witness and judging demeanour, and just generally the use, perhaps in the future, of deposition type approach. Explain, set the scene for us.
Thanks, Marion. So some of us might be podcast fans or follow the US justice system, so you might recognize the person on the screen, which is Elizabeth Holmes. So in terms of context, for those who don't know her, Elizabeth Holmes, she was the founder of a successful company called Theranos. She was the first self-made female billionaire. But unfortunately, she was sentenced to 11 years in prison last year because Theranos, which was a blood testing firm, was found to have collapsed because the technology it was relying on was largely fraudulent. Now, we've talked a lot about evidence in chief. What does that look like? I think rather than describe it, it's probably better to show it. So looking at Elizabeth here, we'll look at just a minute of critical evidence that she gives here to the SEC in 2017, and then we'll discuss it.
When you say we as a company, who made that decision on behalf of the company? I don't know that it was sort of a single decision that was made. It was months of engagement with Walgreens, feedback from counsel, and ultimately a business decision that we, I guess you could say, was consummated with the amendment to the Walgreens contract at a later point in time. I don't think it was sort of a single meeting where we said, okay, let's make the decision. It was sort of an evolution over time.
Okay, but were you the decision maker on behalf of Theranos, and did you sign the Walgreens contract or the amendment?
I did. I signed many of the Walgreens agreements. I don't know if I signed all of them. And yes, and I'm the CEO. I'm the ultimate decision maker for the company. I don't think this was a case where we sort of sat down and had a meeting and said, let's do this. I think it was after a lot of iterative feedback, a mutual decision with Walgreens.
Hey, Ruth, what's the significance of that?
So, Marion, I think there's a couple of significance of that. We very rarely get to see evidence in chief in the courts of England and Wales. But if you look at the evidence that she's giving there, the first is that she has said there very clearly that she was the decision maker at Theranos. She said that in 2017. Now, her defence team argued the opposite in the trial in 2021. And we're left with the question of what evidence do we believe? Now, in terms of the 2017 evidence, I think is really interesting. It's not overly polished, but she's making eye contact. She's managing to be reasonably charming, I think, even in those circumstances. She retains her composure, but there is, of course, a level of hesitancy and vagueness that people often get with a genuine memory. But I think it's very different to the kind of evidence that we would have seen someone give if they were given a written witness statement. And certainly, indeed, it's a little different to the evidence that we saw in the 2021 trial as well. So the same course of action, I think, is interesting when we're preparing our own witness evidence. What level of polish do we think is important, and where's the truth within that?
Yeah, I mean, the jury, they weren't shown, they may have been shown the clip. I don't know how the trial worked out, more recent trial, but the jury effectively found that the answer she gave then in that clip was the truth, despite the completely different presentation at the trial. So did you think she was telling the truth? Do you think you can even begin to judge that from looking at her? Really interesting. Now let's dive into some of these questions and see which we don't think that we've addressed at all. First question up, are witness statements limited to how many pages? Anyone want to jump in there on that one? Page limits?
I think, I'm not sure, is it 50 or so? No,
I need to check. I thought it was a bit lower than that, but around that, yeah.
check the rules.
Hopefully the answer is check the rules. But I think it's an interesting question, because what I am seeing in the arbitration space is an increasing debate about, do we want to limit the length of pleadings, the length of written submissions, the length of witness statements? And there's always that due process concern. You know, am I going to cut somebody out from saying something important? We've got a number of questions coming in about, is it improper about a witness being shown documents that they were not party to at the time and didn't see at the time? Now, my understanding is that that's something one's got to be very careful about. Is that right? I can see you nodding your heads. Yeah, Ruth, come on in.
Just jumping in there. I mean, the test is obviously documents that are necessary. I think you really have to keep in mind, is it necessary to show this person this document? I mean, practically speaking, we all know the difficulty where there's a major point that's probably going to be taken against a witness and you're trying to insulate them against it. All I would say is that we haven't had many trials out that have had these full practice 57AC witness statements, but people are going to be cross-examined on the list of documents. The obvious question would be, well, you weren't there, were you? You've only seen this document last year, didn't you, etc. So think about where is the balance between insulating your witness and protecting them, but also not allowing that fertile ground for cross-examination if you show them a document they didn't see at the time.
Question has come up, are the dangers of influencing memory recall not an inherent part of the litigation process? I think that that's a theme that we have covered. Yes, it is, and you're just going to have to be aware and consider beforehand. I think the thing is, plan it. You know it's going to be an issue. How are you going to take the steps to best insulate this witness's memory and persuade the judge ultimately to place weight on the oral testimony they give? There's questions here about to what extent, if any, does the CPR and guidance accommodate witness statements being written by dyslexics and those with learning difficulties? I think that's a really good question. I mean, I'll leap in first, and I think perhaps Gethin or James might have some other views on that one, which is that, you know, there isn't specific guidance. Know the spirit, and know if you're being pushed outside the statement of best practice, be able to explain why any particular vulnerability requires you to go outside it and record it, because you won't remember under pressure of a live trial why you did it. Keep the record. Did I go wildly off piece, team, on that answer? No? Everyone happy with that one? Then we've got here a number of questions. What if there are no longer any contemporaneous witnesses and the documents don't speak for themselves? Nightmare. Anyone had that? I'd love to know the story that's behind that one. Anyone got any thoughts on that one?
I think that will feed into the pre-litigation advice, really. So
What's that code for, James? What's that code for?
Cry and run. No, but I think that's just the inherent danger of the litigation, I'm afraid. I think there's, if you're finding yourself in that position, that's not a position that I think any of us would envy.
No, we really don't want to be there. I'm acutely aware everyone is super busy. We've got a really big attendance. We're at 1 o'clock. Let's just go very quickly through our key takeaways. I will give you each the opportunity to identify a takeaway. Who's going to go first? Ruth?
So Marion, I think returning to my point about the purpose of it, if you have a difficult question and you don't know how to resolve it and it hasn't come up in the cases yet, remind yourself of the purpose of the practice direction. Imagine yourself explaining to the judge why you took a course of action and why it is in keeping with that purpose. And I think if you do that, sometimes the answer to the issue is clearer.
Okay, Johan?
I think it's important to be mindful of the potential sanctions for non-compliance. The nuclear option is strikeout, so you have no witness evidence, but it's a spectrum. There's costs, there's being critiqued and so on. But also remember, a very aggressive application may well backfire.
Philippe?
Be reasonable. So remember the Curtis case and try to engage with the other side before making over-adventurous applications.
I think James?
I think just to emphasize again, be mindful of the language of the witness and the language in which not only they can speak and give evidence for the purposes of the rules, which is the kind of test, but the language in which they're most familiar in and would give the best evidence for you, or in general.
Gethin?
I think just because the practice direction doesn't yet apply to the division of the courts which your work engages, that doesn't mean it's irrelevant. I think not only is it the clear direction of future travel, but the Gethin principles, as we've discussed, have been applied in a really broad range of contexts. So treat it as a best practice guide, even when you're not in strict rules of the business and property courts.
Last poll, last word to you. Let's put the poll up. Let me remind you while that's coming up that Prince Harry said that things like chronology and cause and effect are often just fables we tell ourselves about the past. Last question to you. Will the factual witness statements you assist with now perform their core function, achieving best evidence at proportionate cost? What's the future looking like for you? Do you think they now will? Yes or no? And thank you for staying on for doing this one. The numbers are holding up. What have we got? What's the answer? I'm going to be interested. Will they now? Okay, great. More than 50%. Thank you very, very much. We're going to be doing more of this. It's not ever going to go away. It's the core thing we do. Thank you very, very much. I think we can now leave.